ladies and gentlemen. It will be very useful for the industry stakeholders, both employers and employees, to understand the legal aspects of the pandemic. We have been lucky today to have with us today the sharpest legal minds in the country to throw light on some of the important legal issues. Known and highly respected in his capacity and devotion for work and his legal acumen, join me in welcoming Senior Advocate Milind Sathe, who is also the President of the Bombay Bar Association. Thank you, Mr. Sathe, for coming on the show today with us and address our petrochemical colleagues.
Thank you.
The first question for you today, Mr. Sathe, is that the Disaster Management Act of 1897 was framed about a century ago and is still valid and being invoked. First, coming to the government directives, what are the rights of the government in such happenings of epidemic which impact the industry?
The Disaster Management Act is of 1897. It is a pre-constitutional law, and even today it is valid as an existing law. It's a very short act of 3 sections, and all that it does is it empowers the state government as well as central government to make temporary regulations and to take such measures as are necessary for prevention of either outbreak of epidemic or the spread of the epidemic. So that's the power which is conferred upon the state and central government. Epidemic, as is defined, is as a large number of people are suffering from the same disease at the same time. That's generally known as epidemic. So in such circumstances, the state as well as central government can make regulations for taking such measures for prevention of outbreak or prevention of spread of epidemic. Now, these measures are, one of the measures is specified in the Act itself. Since it is an Act of 1897, there was no air travel. So it only provides that the passengers who are traveling by railway or by ships can be separated, segregated in hospitals or other places. So that's one of the specific measures which is provided. But today, the other measures can also include a variety of other measures, some of which have been taken by the states and the central government to prevent the spread of COVID-19. That's broadly the scope of the Epidemic Act of 1897. Of course, today when the state or central government do take measures under this act, since we are in a post-constitutional era, we have Part 3 under the Constitution, which guarantees fundamental rights to not only citizens, but persons who are in India, as well as legal individuals like corporate entities, companies, LLPs, etc., or partnership firms also. So the measures which are being taken by the state as well as central government would have to be valid in conformity with the constitutional provisions. So yet the Act provides for the special measures to be taken by way of temporary regulations. Those measures will have to be in conformity with the Constitution of India.
Thank you for clearing that for us. I'm sure, like me, many people would not be aware about that. Under the lockdown, Mr. Sathe, many manufacturing units of my colleagues were closed and their customers did not receive the products and the goods as contracted before the epidemic and the pandemic. What is the legal recourse available for the buyers for the non-delivery?
For this situation, you will have to rewind and go back to the date on which the lockdown was declared. So on that day, what was the situation? The situation was the parties had legal contracts for supply of goods of specified quantity, quality, and the date of delivery, and the consideration. So the buyer has to pay the consideration and buyer has to receive the delivery. So that's normal contract. So because of epidemic, that time is suspended for performance. In a sense, the limitation for seeking specific performance has been extended by the Supreme Court. But without that, the normal remedy would be, if there is a breach of contract, there are 2 remedies generally provided. One is the party who wants performance of the contract can sue for specific performance, in the sense that you ask for performance to be completed. Alternately, you can sue for damages for non-performance. So that's the second remedy which is available in a contract. Now, there are certain contracts which are required to be specifically performed, like, for example, purchasing of a painting. There will not be any other painting of that kind available, so the damages will not be sufficient remedy. So there are certain contracts for which the damages in terms of money is not an alternate effective remedy, where specific performance is generally granted by the court. Now, coming to the issue arising out of lockdown, you can still sue for specific performance and ask for either specific performance or damages or refund of money with interest. So these are the three possible remedies. Of course, the party who is not in a position to perform can cite the reason or justification for non-performance being the COVID situation. So in that case, whether COVID is a justification by way of a force majeure, which is another legal term for in the performance of the contract, whether force majeure is available or not, that would be defense which will be tested when a suit is filed for specific performance. But broadly, the answer is the party who is seeking performance will have to sue for performance either in a civil court or if it is a service in a consumer forum, depending on the jurisdiction, the territorial jurisdiction, pecuniary jurisdiction, and what the relief the party is seeking. So that would be broadly the remedy.
Okay, so the measures are available. Now they'll have to be tested that from every different party to party and in their area of jurisdiction. You just mentioned the force majeure. What is the significance of this term in this situation and how can it protect the stakeholders, sir?
In performance of a contract, which I just mentioned, there are three aspects. One is that the party performs the contract. Second, party says that because of circumstances, the contract has stood frustrated and therefore party is discharged from performance. And the third is, which is known as allocation of risk or the distribution of risk, which is covered by the concept of force majeure. Force majeure is a French term, which is derived from a Latin term called vis majeur, that is superior force. So force majeure consists of two aspects. One is acts of God, which are generally the typhoons or tsunamis, earthquakes, or even epidemic. And the second are the acts which are beyond the control of the party and the party is not responsible for it. Then those would constitute as force majeure, such as war or a civil strife or the change in government policies, which makes impossible for performance of a contract. That would fall in the concept of force majeure. So these are varieties of factors which are covered by force majeure. Of course, in a particular contract, when you are talking about enforcement of a contract, you will need to see what is the force majeure clause in your signed agreement. The force majeure clauses generally provide that if there is an event of force majeure, the party who is invoking force majeure as a justification for non-performance of a contract has to give notice to the other party that I'm going to invoke the force majeure. So that's one. It depends on the contractual provisions. Once that notice is given, then the force majeure starts operating till the force majeure event is continuing. After the force majeure event is over, then you go back to the date on which you had stopped and then you seek specific performance. So the force majeure is a kind of defense which you can, as a contracting party, take for non-performance or reduced performance or incapability of performance. But there is one important aspect that because of COVID-19, which would definitely be considered as a force majeure event, that's not a solution for every problem. There is a concept called but for. But for in the sense, but for the COVID, you would have been in a position to perform the contract. For example, there is a classic case of shipment. And the defense was that the harbor, there was an accident in the harbor, so therefore the ship could not sail. Now that was considered as not force majeure because the party's goods were not ready. So even if the harbor had not damaged, he was not in a position to perform. So the force majeure is available only where the defense of force majeure is only but for. But for the force majeure, you would have been in a position to perform the contract. Then alone force majeure would be available as a defense, as an allocation of risk of contract to reduce the risk of contract and to justify non-performance arising out of force majeure events. So that's broadly the concept of force majeure.
So companies cannot just use it as a blanket cover that, under everything. It has to be very, very on the but for clause will come up.
It is like normally in insurance contract also, but for this event, you would have been in a position to perform. And if you are in a position to perform, then you can invoke the force majeure clause. if otherwise also in a contract you are lagging behind your milestones, or the milestones or the performance which were required on a particular deadline, you were not ready, then of course you cannot invoke force majeure, because you otherwise also would not have been performing.
Fair enough, fair enough. This debate has been very active in our industry, Mr. Sathe, that can an employer of a company be justified in reducing or altering the salary, staff remunerations, despite of them being first profit-making unit? We'll come to the non-profit-making units second.
The relationship of employer and employee is categorized into two aspects. One is the employees who are of a workman category, and the employees who are not of workman category. Of course, the non-workman categories are also categorized as blue collar, white collar, etc. But those are non-workman category. So insofar as workman category are concerned, those employees are governed by the three acts, which are known as Industrial Disputes Act of 1947, Payment of Wages Act, and the Minimum Wages Act. So their relationships are governed by these acts. Now, Payment of Wages Act mandates that the employer must make payment of wages to the employee unless he has voluntarily abstained from work, then he is entitled to deduct the wages. Now, COVID-19 pandemic would be a justification for an employee not to report to work because he is unable to reach the work. And therefore, the relationship of employer-employee would continue. Employer would be required to pay the wages even during this time, because the workman has not abstained from work at his own volition. He was prevented from doing. So therefore, he cannot be regarded as absent from work. That is insofar as workmen are concerned. Insofar as non-workmen category are concerned, their relationship is governed by the service conditions, which is in a part of a service contract, or if the organization has service regulations, then they are governed by the service regulations. So in such a case, you will have to see the contract, what it provides for in such a situation. And in that case, on that basis, you will have to take a call whether the employer-employee relationship can be altered or not. Now, insofar as government's powers are concerned, government cannot alter these service conditions. In fact, the government did issue an order on 20th of March and 20th of March 2020, immediately following pandemic. And it directed that all employers must continue to pay wages to its employees, both workmen as well as non-workmen category. That was challenged in Supreme Court. That challenge is still pending in Supreme Court. In fact, the Supreme Court has passed order on 12th of June, that is 2 days back, and has noted that that order of 20th of March was withdrawn on 18th of May. So it was in force only for 50 days, 50 days. Today, that order is not in force, which was issued by the government under the Disaster Management Act as well as the Epidemic Act, directing employers to pay the salaries regardless of the fact whether the factories were working or not, whether the employees had reported for duty or not. So that order is gone. So there is a question of about 50 days where this order was in force. So the Supreme Court is examining the challenge by the employers and the industry association. But in the meantime, what Supreme Court has done is Supreme Court has directed the Government of India, state governments, Reserve Bank of India, and the industry representatives to sit together and try to work out a settlement, negotiated settlement as to what is to be done for salaries of these 50 days. But in my opinion, the government would not be justified, including under the provisions of Epidemic Act or Disaster Management Act, to alter the service conditions, both in cases of workmen as well as in cases of non-workmen categories, by resorting to those provisions.
So we'll have to wait till when the Supreme Court directive really comes after their negotiations and internal meetings have finished.
Yes. So what will happen is, if the parties arrive at settlement in so far as these 50 days are concerned, then there will be no issue before the Supreme Court to decide whether these circulars and these directives were valid or not. And in all probability, the parties will have to settle these matters because both employers and employees know the difficulties. The employees know the difficulties of employers, and employers also know the difficulties of employees. So in all probability, this is a matter for negotiated settlement.
Agreed, sir. Very well. Every one of us is facing the same, and we are, I mean, doing the best that is possible, the employees as well as the employers. Mr. Sathe, the unlock phase has begun, and the new norms are for workplace, such as social distancing, hygiene, mask, sanitation, as prescribed by the government and the health authorities for the employer. They're all set out. What are the reciprocal obligations for the employers as well as the employees in this space?
Insofar as the new norms are concerned, they are only an additions to what would have been otherwise the service conditions. For example, at an industry, as a factory or at an office, if a cafeteria is run, the cafeteria must be in a hygienic and sanitary conditions. For that, there are standard requirements of a cafeteria in a workplace under the Factories Act or other normal laws where you run canteen under the municipal laws. So therefore, that is a normal requirement. Then insofar as the treatment at a workplace is concerned, what facilities are available, that is also governed by the service conditions and the service regulations. For example, whether the employee is provided with food, canteen facilities, etc., or the lunch break, etc. These are all worked out as part of service contract. Now, these specific conditions which are now required to be followed, like social distancing, that you will be sitting at a distance in the offices by maintaining social distances, sanitization, masks, etc. I think these are all required to be mandated because that's not only necessary under the law, and that would be a requirement under the Disaster Management Act as well as Epidemic Act, and that would be held to be valid even if it is challenged in a court of law, because that's necessary for prevention of spread of epidemic disease. And therefore, these guidelines would be valid and they will have to be observed. If there is an additional cost, which indeed there would be, that cost will have to be borne by the employer as an additional facility cost. And that will be part of the expenditure of the establishment or overhead expenditure. So that would have to be borne, and that would be a valid expenditure, unquestionable expenditure in view of the epidemic.
Okay, so all of us will be ready with that when we actually open the offices in full bloom. Mr. Sathe, when an employee is posted at offices or locations which are classified as difficult areas or hardship postings, they are awarded an additional compensation or a hardship allowance. What would the present pandemic be considered in such a situation of hardship if the employee asks for an extra allowance or additional compensation?
This will not automatically qualify as a hardship posting, entitling an employee for a hardship allowance. There are 2 or 3 requirements. For example, in the Mumbai metropolitan region, a person is staying at Vasai Virar and has to report to Churchgate, VT, or Nariman Point, etc. Now, in that case, he is not able to travel by a normal transport mode, which is not available. And if the employer insists that such a person must attend work, then in that case, the employee would definitely be entitled for the additional expenditure he would incur for traveling. So that's not an additional hardship allowance, but that's an additional expenditure the employee would be incurring. So that's one illustration where the additional expenditure would have to be borne by the employer and employee would be entitled for such expenditure. That is one. 2, there might be situations which will arise not now but later, that the offices start functioning and some employee contracts disease in the office. Then there might be cases where employee would sue the employer saying that I contracted this disease because of the neglect at the office premises, but for the precautions which were not taken, I would not have contracted this. So in such a case, there would be like a normal case of a tort, negligence case. And in case negligence is proved on the part of the employer, then there would be an additional expenditure required to be paid. The normal expenditure which the employee would suffer for hospitalization, other medical expenses, etc., that will have to be borne by the employer. Conversely, if employee is negligent and he causes the spread of a disease in the office by his negligence, the employer would be entitled to take action against the employee also. Of course, there may not be a monetary compensation possible from an employee, but there can be disciplinary action for non-performing in a manner which is appropriate to be performed in an office atmosphere. So there would be such situations which definitely will arise over a period of time.
It's a little subjective, Mr. Sathe, though, kind of pinpointing that whether the employee was acting as he was supposed to do, taking the precautions, or the employee, it's going to get in a little hazy zone there.
It
And,
will definitely be.
yeah, would there be cases where the employee can also put cases against the employer over and above the medical expenses and the expenses that are really incurred on a higher level? You think that is possible also?
No, as I mentioned, there could be 2 or 3 heads of expenditure which employee can ask for as additional traveling expenditure or additional burden which is faced with for attending the offices. That is one. Or if he contracts a disease and suffers as a result of the disease being contracted in the office, then of course employee will have to prove that he contracted the disease in office, which will be possibly difficult to prove. But in case he is able to do that, then there would be a liability of the employer.
Understood. Can this pandemic be considered under standard medical insurance policy? Would the expenses towards quarantine, separation, hospitalization, medication be covered under the Mediclaim insurance?
uh, as perhaps everybody in this country has seen, that the medical insurance policies are most difficult policies to enforce. The insurance companies always find something to get out from the medical insurance policy, saying that there was a separation, a particular disease was not disclosed, a particular condition of health was not disclosed, etc. And they try to renege from the policy. As against that, the insured seeks to enforce the policy. So that's generally the situation of enforcement of medical policies in our country. Now, the answer to the question whether the situations arising out of COVID would be covered by a medical insurance policy or not will again depend on the policy terms of insurance. Insurance policy is like a normal contract. So when you talk about enforcement of a contract, we have a Contract Act of 1872, and there are 2 defenses for performance. Either it has got frustrated, or the contract was void, or there are justifications for non-performance like force majeure, etc., which of course will not apply in a medical insurance policy. But the terms of the contract will have to be seen whether any health condition is covered by the medical insurance policy. Like, for example, in motor insurance, there are those third-party covers. So no matter what happens to the vehicle, no matter whose fault it is, whatever arises out of a motor vehicle accident, it is covered by the policy. That is called third-party comprehensive policy. So if your medical insurance policy is of that nature, like all comprehensive policy, any ailment you suffer, why you suffer, where you suffer, etc., is not then questioned, then in such a policy, COVID would be covered. But if otherwise your normal medical policy is covering the stated ailments like a heart ailment or accidental ailment, etc., then possibly the COVID will not be covered by that insurance policy. The other normal law for interpretation of medical policies is what is the purpose of policy. So the courts look at the whole policy and decide whether it is all comprehensive policy or not. If it is all comprehensive policy, then COVID would be covered under that policy.
Noted. I think after this pandemic, a lot of policies will require a lot of reworking, and a lot of clauses will be added, not only for the insurance, but in our normal work orders also. I think a lot of people will have to make a lot of changes. Is an employee within rights to demand work from home? If his presence is required in the office, can the employer kind of force the employee to come, or the employee can say that, no, I will only work from home?
There are 2 answers to this question. First is, you look at the service conditions or the terms of employment. If the terms of employment require you to do a quality and quantity of work regardless of your attendance in the office, then possibly the employee can say that I will perform this task, which is my job, from wherever I can. So it all depends on what are his service conditions. That is 1. 2, if the employer says that the employee must attend office because now that the lockdown is relaxed and there is a permission for the employees to travel and attend offices, then the employee cannot have justification for not attending office. An employee, as a matter of right, cannot ask that I will work only from home and I do not feel secure or safe to travel, and therefore I will not travel and I must get work from home. Employee cannot, as a matter of right, demand that.
Oh, that is what the legal angle to that is. Okay. Um, Mr. Sathe, we will now be in the third month. We are in the third month of pandemic. Are there already cases filed which have disputes between employer and employee that you see in the courts, or it is still warming up right now?
There are large number of cases which are filed in respect of both not only employer-employee, but also in respect of the contracts, general commercial contracts which we talked about. The employer-employee cases are about non-payment of wages. Now, non-payment of wages has happened in respect of the two sets of industries. One which has been shut down because of pandemic, and second, the industries which have been partly functioning, not necessarily to their full capacity. So these are the two sets of industries. And yet another set of industries is that one industry which has suffered financially, their liquidity position has gone very bad. And the second set of industries which are doing very well regardless of the pandemic. Like for example, the general manufacturing industries have not been affected by pandemic to a great extent. So in such cases, the employers have been directed under that circular which I mentioned, which was issued by the central government on 20th of March 2020, directing them to make payment of wages regardless of anything, whether the industry was closed or not, whether industry was functioning with full capacity or not. Regardless of that, they were directed to make the payment. So that case on behalf of general industry has already gone to the Supreme Court, and as I mentioned earlier, the Supreme Court has asked the parties to arrive at a negotiated settlement. So that's one set of cases. The second set has, of course, come about is the commercial contracts. For example, the shares are pledged and there is a default. So the person to whom the shares are pledged, he went to market to sell the shares. Now the stock market virtually crashed at the onset of pandemic. So therefore, the person who had placed the shares, they of course complained that you cannot sell the shares now because they will not fetch the proper price for which they ought to fetch. So those kind of cases have also gone to court about the enforcement of contractual relationship, and they will continue to rise.
Yes, as the factories and the offices start opening up there and the new situations start coming up, the cases will definitely.
There's like other case which is also pending in Supreme Court is about the cancellation of flights, domestic as well as international flights, and parties have applied for refund. And the airlines are saying that we have not cancelled the flights, so we were ready to fly and therefore we will not pay refunds, either partly or fully. So that's a classic case which will have to be contested. Possibly the court would suggest parties to arrive. Case will have to go to consumer court for non-performance in service, etc. Because there cannot be a general formula for lakhs and lakhs of passenger tickets. What is the solution? Whether airline, because airline industry is also equally suffering because of this. They are not generating any revenue. They would say that we don't have revenue. We will have to pay the salaries of our staff under the other directions issued by the central government. Then whatever cash flow we have, if we have to pay refunds to the passengers, they will be in a very, very difficult and precarious financial situation. So this is another set of cases which have already accrued and are pending in the courts.
It will be very interesting what kind of judgments are going to come out of these cases. They're going to be one in a lifetime that we're going to be seeing a lot of them. Mr. Sathe, what is the legal resource available to a company or a stock manufacturer if the customers are not paying their dues, citing the problem because of the pandemic-related economic situation? They would have already received the goods, but now they are not paying up. What is the legal resource that a company can take?
In such a case, you can go back to 17th of March when pandemic was declared and file the case as if you are on 17th of March. That you have sold the goods have been delivered, there has been no complaint about the quality and quantity of goods, and the consideration has not been paid, and you will be entitled for receipt of that payment. As I mentioned earlier, the Supreme Court has passed order in March, I think the 20th of March, under Article 142 of the Constitution, which is a all-encompassing power only of the Supreme Court to pass any order to complete justice. So the Supreme Court has passed an order that limitation periods. Now, limitation period is the time within which you must sue. For example, if your monies are due from a party today then under the Limitation Act, you must file your action within a period of 3 years. And if you do not file, then your claim does not go, but your remedy is barred. So you cannot file a case in court if it goes beyond limitation. So limitation becomes a very important point. So what Supreme Court has done is Supreme Court has passed an order virtually ordering that the limitation would stand suspended. So this period till date, the lockdown is like, for example, from 17th of March till 8th of June, will not be calculated in terms of limitation. So suppose your 3 years were expiring on 10th of April. You were not in a position to file the suit before 10th of April. Your time has got extended to 8th of June. So that is the limitation which has extended. That is one aspect. Second is you will have to file suit for recovery of money. Now, there is an act known, depending on what kind of industry you are, whether you are a big industry, whether you're a small, micro or medium size industry, there is a special act for small, micro and mini industries known as Micro, Small and Medium Enterprises Development Act of 2006. Now that act has provided two things. It has defined what are these industries. So small industry manufacturing is say 25 lakhs up to 25 lakhs. Then medium is, micro is 25 lakhs, small is 25 to 5 crores, and medium is 5 crores to 10 crores. In respect of manufacturing and in respect of provision of services, micro is 10 lakhs, the medium is 10 to 2, medium is 2 to 5 crores. So that's the classification of industries. Now for such industries, there is a special provision. In case your payment is delayed beyond the due date, which is either the date mentioned in the contract or 15 days from the service of from the delivery of goods or delivery of services, then beyond 15 days, you are entitled for a special additional interest at the rate prescribed by Reserve Bank of India. So that's a special facility for these small, micro, small and medium enterprises. So if you fall within those categories, your income is protected, and there is a fast track mechanism under that act for recovery of that interest and your dues. There is a council and arbitration through that council under the act. So if you fall in that category of industry, you can get a fast track remedy under that act for recovery of your money. In case of other normal industries who are not micro, small or medium industry, you will have to file your cases depending upon the quantity in a appropriate court depending on its pecuniary jurisdiction, territorial jurisdiction, or you can file the insolvency proceedings against your person who is not paying you under the insolvency code before the National Company Law Tribunal.
That's going to be very useful, I think, if the law is already protecting the rights for a lot of, because our industry has a lot of the companies that fall under the categorization specified. So that is really going to be helpful. We're going to shift to another angle now. Citing the pandemic, can the legal obligations between the landlord and the tenant in respect of the rented premises for either residential or commercial or industrial use, can they be altered?
The landlord-tenant relationships are governed by two sets of laws. One is the Special Rent Act, which is there in every state. And there is another law called Transfer of Property Act, which is the All India law. So the persons, the landlord tenants who are not protected by Rent Act, they are governed by the Transfer of Property Act. Now, this is also a contract. The tenancy is also a contract, but it is either it's a lease. It could be a monthly lease or an annual lease or 99-year lease, etc. So the landlord-tenant relationship is basically lease. So it is either governed by the Rent Act or it is governed by the Transfer of Property Act. In fact, in Delhi High Court, there are a large number of cases filed of that famous Khan Market tenants, saying that their shops are shut and they are not in a position to pay rents. Now, the Delhi High Court has already given a verdict that the landlord-tenant relationships are not altered because of pandemic. The law is that as long as you are in possession of the premises, whether you are in a position to use it or not, and if you are not in a position to use, what is the reason for non-use, the landlord is not concerned. As long as you do not surrender the tenancy and hand over possession to the landlord, you are liable to pay rent. And therefore, the rent doesn't get suspended neither under the Transfer of Property Act nor under the Rent Act. And therefore, the liability of tenant would continue. The government had issued circulars. They were not, they were in the nature of advisories. that the landlord should not be harsh, they should not start eviction proceedings if the rent is not paid, etc. Now that those circulars have no legal sanctity, because the government cannot by circulars change the contracts between landlord and tenant. So the legal position is there is no way the tenants can skip the liability. Again, possibly whenever the large number of cases go to court, the courts would ask that they should sit across with the government representatives and try to work out a solution, because everybody has suffered. Tenants are not in a position to pay, particularly in cases of commercial and industrial premises, because their businesses are shut. Residential, of course, you can't have any justification for non-payment of rent. But industrial and commercial, they can have some justification for non-payment. As against that, several landlords state that their whole income, their survival depends on the rent. So therefore, they are equally affected. So therefore, this will have to be again worked out on the basis of a negotiated settlement. If these cases do go to rent court for eviction on non-payment of rent, in cases of non-payment of rent, there is a provision in almost every rent act that on the first date of hearing of a case, if tenant offers to pay the arrears, then his tenancy is not terminated. Then the case gets dismissed. So he gets
a standard clause. This is a standard clause.
Almost in all rent acts, there is such a provision.
Okay, understood. Mr. Sathe, it looks like a lot of negotiations and arbitrations are going to be happening after life resumes to normal, because most of the cases, because it's the first time, is going to probably go the arbitration route. A lot of situations.
Not even arbitration, they will have to go to mediation and conciliation. Because mediators would be entitled, mediators would be in a better position to bring about a settlement in such cases. Because mediator, normally in mediation, what happens is mediator talks to both parties separately and tells them their pros and cons of the case, or possibility of a result, etc. And then has a general meeting with both the parties and then decide and tells them what is the best via media for both of them. And if parties are reasonable, then of course mediation will work. So in these cases, most of these cases, it will have to be through mediation, because in courts, cases will be long drawn. These cases cannot be decided overnight. That is one. And second, there is no easy answer to these problems.
Agreed. They're subjective. Can the landlord charge interest on the delayed payments of rent if it's not in the contract, in the agreement?
Yes. Under the Rent Act, there is no provision for charging interest. Non-payment of rent is a ground for eviction. So when the landlord gives notice that you have not paid rent for last 6 months or 3 months, etc., then he gives notice for terminating the tenancy, and then he goes court for eviction decree. In such cases, under the Rent Act, not under the Transfer of Property Act, but under the Rent Act, every Rent Act has a provision of the tenant offering the payment of arrears of rent on the first date of hearing, and the case is dismissed. But in Transfer of Property Act, they will have to be interest. The cases which are not governed by the Rent Act, they will have to be payment of interest if the landlord is willing to accept the interest. But if he insists on the default in payment of rent as a ground for eviction, then of course interest also will not solve the problem.
The intent is only to get them evicted, so nothing can happen there. Understood. Mr. Sathe, our industry, which is the petrochemicals and energy industry, there's a lot of debates happening on the anti-dumping duties, because our industry imports a lot of raw material, a lot of finished goods from China, from other countries, and also machinery. A lot of import happens because of the nature of our industry. Can the pandemic situation be a justification for the Indian government to consider and levy anti-dumping duties on imported goods, as I mentioned, particularly from countries like China?
See, anti-dumping is a separate independent subject. Anti-dumping, of course, is now recognized as a part of a World Trade Organization Charter. There is a GATT, that is General Agreement and Tariff and Trade of 1994, particularly Article 7, which deals with anti-dumping duties, which is a part of WTO Charter. Now, that has a mechanism for anti-dumping duties. Now, that mechanism is adopted in the Customs Tariff Act of India by way of an amendment in 1995. And for anti-dumping, no matter what the reason for dumping is, whether it has arisen out of pandemic or which is otherwise also happened, there is a procedure under that act. And that procedure broadly is, if there is an import or import from another country, maybe China, Malaysia, whichever country, into India at a price which is lower than the exporting country's domestic price. Like for example, if China is selling a product at 100 rupee equivalent and it is selling that product in India on export at 75 rupees, it is actually dumping. The dumping actually happens on two reasons. One is that there is no market in the home country, or alternately that country wants to have a dent in the exporting country, in the dent in the market in India, the exporting country, like the Chinese companies or Malaysian companies, they would want to establish themselves in India and therefore set up and they want to start dumping the product at a cheaper price. So that is the first trigger for anti-dumping. Now, whether that anti-dumping trigger happens because of pandemic or not is irrelevant. If the trigger must happen that the exports are happening to India at a price lower than the domestic price of an exporting country, that is one. Then either the government, that is the anti-dumping authority on its own, can take cognizance of this, or an industry with more than 50% representation of that industry in country, they can make a representation and request for anti-dumping measures being taken. So those measures are then initiated, and if there is a prima facie case of anti-dumping made out, then the government imposes what is known as provisional duty. Then there is a complete investigation which has to be completed within a period of 12 months or extension up to 6 months, so up to 18 months. And after the investigation, if it is found that there is a dumping, then the final duty is levied for a period of 5 years. So that's the normal procedure for anti-dumping duties being levied. But for that, the COVID may be a trigger. COVID may be a reason for the countries to export and dump products in India. But to levy anti-dumping duties, government will have to follow, the government and both industry will have to follow this procedure.
There are only set procedures they have to all follow. There's nothing that the pandemic special cannot be taken as an example.
Pandemic could be a trigger for dumping, but the procedure will have to be followed under the Customs Tariff Act.
Already said there.
Yes.
Mr. Sorry, I should be calling you Dr. Sathe. This is completely apologies on that front, sir. Dr. Sathe, no, I'll make amendments from now on. Dr. Sathe, a lot of focus has been there on the hygiene and the health, and especially for all consumables like the food, etc. Can the FDA authorities during the pandemic strictly enforce packaging standards and other stipulations regarding branding, labeling, shelf life? Can they do that now to all the FMCG and the packaging companies?
So far as the Food and Drug Administration and Act is concerned, there is no provision for waiver of the requirements of that Act in respect of the standards, labeling, specifications, shelf life, etc. And some would argue that the pandemic is, in pandemic, those conditions must be more rigorously enforced because the health is paramount and the health care is paramount in these times. So therefore, there cannot be waiver of the conditions under the FDA Act, including the declaration of contents, the packaging, labeling, shelf life, or the MRP. Maximum retail price mentioning, whichever is required to be mentioned on particular products. I think there will be absolutely no waiver permissible under that Act, regardless of the pandemic.
And on the other side, you say, can they kind of put a regulation saying that it has to be more stringent now? Can FDA go to that?
There is nothing to be stringent. There are standards prescribed, they have to be followed. And those standards are prescribed from 2006 onwards. So they are for universal times, pandemic or non-pandemic time.
Okay.
And these are, see, these products, anybody who is engaged in the food business, and the food business includes the small marriage caterers also. So if a marriage caterer is carrying his utensils in a truck, he is also required to be licensed because he is a food supply in the food supply business. So that law is in force from 2006. It's not very rigorously enforced in respect of this non-organized sector, but pandemic can certainly not be a waiver of those provisions.
Rightly so. Dr. Sathe, how are the courts functioning right now? Are they going virtual? We're all very interested to know that.
Insofar as high courts are concerned, which are at, of course, major cities, capital cities of India and Supreme Court in Delhi, where the pandemic cases, the COVID cases are in large number. From 17th of March, most courts, not most, all high courts and Supreme Court have stopped physical functioning. In rural areas, the taluka places, district places where there is there are no cases of COVID, the courts have been functioning physically. Insofar as high courts are concerned, the courts are functioning only through virtual courts. Now, for example, Bombay High Court has been functioning from 17th of March on virtual basis, and we had lots of glitches about the systems which are now not allowed to be used by the government agencies or even courts because of the security concerns. So the NIC, that is National Information Center, had to devise the new systems for video conferencing, etc. And there are teething troubles, but now there are about 10 courts in the Bombay High Court functioning on virtual basis. Supreme Court is virtually functioning on full-scale basis on virtual court. But in virtual courts, currently only urgent cases are being taken which are filed, which cannot wait till we resume physical courts. Only those cases are taken. For normal cases being taken in virtual courts, there is one logistic issue. For virtual courts, you actually need paperless court. So you cannot have the files. You need all papers in digital files. So both lawyers, whichever are operating from various places, so 5 lawyers in one case could be sitting at 5 different places. Judges are sitting at 6 places. So they all must have same digital paper book. So that is not possible to be done of old papers as of now, until the courts reopen, until staff is available to make digital paper books. So therefore, as of today, only very urgent cases which are filed now or where digital paper books are available, they are being taken. Delhi High Court, of course, has a head start because Delhi High Court is virtually paperless court for last 4 or 5 years. So therefore, Delhi High Court is in fact functioning on a full-fledged basis on virtual basis.
Oh, we have an example right in the country that it is paperless. Oh, that's news to us, but good to know that. How does the court decide the priority, Dr. Sathe, of which are the cases to be heard and which can wait? Isn't it subjective, or there is a category?
It is subjective in the sense the judges do decide about the urgency, but the urgency is decided on the basis municipal corporation is threatening disconnection of water, or electric supply company is threatening disconnection of electricity, or the bank guarantees are being invoked under the contracts, etc. So these are the kind of cases which are urgent, or you need like you have to do some pre-monsoon works and there is a injunction in a infrastructure project, so you need to do those works. So those are the kind of cases. So that is how the urgency is decided. So on that basis, the courts decide whether this should be taken or it can wait for a while. For example, the schools are now reopening on virtual basis, and the government has issued directive that you should not increase the fees for this year, or you should not force them to pay fee in lump sum. You give them installments, etc. So some schools are not honoring that. Some parents have gone to court, etc. So these are of course urgent cases. So that's broadly how the urgent cases are. This urgency of the case is decided.
Dr. Sathe, already there were a lot of pendency of cases as we keep reading in the media. With this pandemic, you think the load will kind of really become huge, or when our courts actually become paperless, they will probably in due course of time, all of them, and digital hearing continues, will the speed increase, you think, of hearing the cases?
The number of cases which would have been filed from 17th of March till today, or till the courts physically reopen, those cases of course will be relooked by the parties. Some of the cases may not be filed now, which would have been filed in normal times. So they will be relooked by a person who was otherwise inclined to go to court. He may not now go to court. So we cannot predict whether all those cases would be now filed or not. Possibly they may not be filed. So that is what will happen once courts reopen. And today, if there's somebody's limitation is expiring, of course that limitation is extended, so he can wait till the courts reopen. That is one. Once we start physical courts, then possibly now the time has come that we will eventually settle down in hybrid system. There will be some physical courts, some virtual courts, and once we have paperless court, then that court of course can function on virtual basis. So there will be some kind of hybrid system which will evolve over a period of time, and that's definitely going to be the future for the Indian legal system.
Understood. And you well pointed out the fact that the mindset of all of us have changed so much during this pandemic that going to the law or going to the courts, if it can be avoided, people will find more sanity in that. Dr. Sathe, in the current situation, what will be your advice to the industry stakeholders as regards enforcement of their claims and their obligations?
See, those claims which must be enforced, they will have to go to court. Like for example, you earlier mentioned that goods have been delivered, the monies have not been paid of the contracts. Now there is no option but to go to court. Now, once you go to court in such a situation, the other side would definitely come forward and say that he is not in a position to make full payment as of now because of the industry situation. So in such cases, again, courts send these commercial cases for mediation. And the expert mediator would advise both the parties what would be in their best interest, so these cases could be settled. So that is one way. Second is the cases which need not be filed, they will not be filed, because now people would want to save even the cost of litigation, perhaps. That is second. Third, as I mentioned earlier, the landlord-tenant dispute or employer-employee disputes or these airline refund disputes or these bank guarantee disputes, etc. The courts would say that these matters strictly cannot be decided in court of law because their contracts are specific, or insofar as workers are concerned, there are laws. So therefore, they cannot be a universal solution. So therefore, court has, as done in that circular of employer-employee wages cases, send the matter for negotiated settlement through the aegis of Government of India, state governments, and Reserve Bank of India. I think that would be a proper course to go about in these cases. That is one. Secondly, when you want to get back on your feet, they will be give and take, because they are between the employer-employee as well as the purchasers and suppliers. So they will have to be re-establishment of relationships. So that possibly would have to be renegotiated now.
Understood. And I think, yes, your advice will be useful for all who are going to be hearing this. Dr. Sathe, plastics had a little negative vibe, if you remember, before the pandemic. And there were a lot of laws and bans on plastics across different states. And our industry, I belong to the plastic industry, we were trying to bring to the notice that it is only the post-consumption usage that was an issue. The product itself was a wonder product. During the phase of fighting corona and post-corona, would the authorities be justified in enforcing the ban on plastics? Since of course, I can be biased, but there is no other alternative to plastics. And also the focus on hygiene, the focus on safety has increased so much, and plastics has emerged as a hero in this pandemic.
Undoubtedly, during this time when we are propagating the contactless deliveries, etc., so the plastic has emerged out as a very, very strong packaging material during the deliveries which are contactless. That is true. But at the same time, the ban on single-use plastic is in force almost in all states in the country. There are plastic rules of the central government of 2016, as well as every state government has its own plastic use rules where single-use plastic has been prohibited. And there are orders of NGT also seeking directing enforcement of this single-use plastic. As of today, during pandemic, because of this necessity of this contactless deliveries, etc., there isn't a strict enforcement of that, because you're seeing a lot of plastic being used as even including as a single-use plastic. But the problem of single-use plastic actually occurred because the industry and the other concerned persons were not in a position to control the post-use single-use plastic. And that was choking in the systems like rivers, the sewage canals, etc. It was going into the stomachs of animals, fish, etc. So that is what is portrayed against the industry. So that is a major problem, whether during pandemic or even post-pandemic, that if the industry is able to take care of post-use disposal of single-use plastic, which is a very difficult aspect, but that's the key to the problem. And as of COVID, there is not strict enforcement, but the COVID will not be a justification for reintroduction of single-use plastic.
Okay, our industry will take that verdict. Dr. Sathe, we are all hoping and praying to return to our old ways of working soon, and this calamity is over. What would your timeline be in returning to the pre-COVID era, as we may call it, since you are known to have a very logical mind, and after kind of looking at all the numbers and the way the world is going?
This is something unprecedented. We had some instances of like MERC pandemic in 2012, SARS in 2004, but that got localized in a country or in some region or few countries of a continent. There is nothing in recent history of such enormity like the current pandemic. Possibly there was a Spanish flu of 1918 that also traveled only where the soldiers traveled and carried the Spanish flu. And that's why it came to India from the returning soldiers. But otherwise, it did not go to the places where there was no travel. Now that we have a seamless world travel, either through ocean liners or airliners, the spread is quite rapid and with lightning speed. Now with that, the numbers in the world are still alarming. So we don't know when those numbers would actually come down, because this social distancing and mask is going to be, I think, new norm for at least another 6 months.
Okay, so 6 months is what you are expecting from whatever data or whatever
At least.
At least. Okay, so the conferences we are going to be planning after 6 months then. Okay, Dr. Sathe, we really have to thank you for your time and also sharing of the legal intricacies of the cases that must be and the situations that must be in everyone's mind in our industry. All this is going to be really helpful. You've enlightened us in a lot of facts, and also the session has been very beneficial because all of us were focusing on how to get our work back together. But these different situations which all of us will have to face one or the other time were looming large in our minds. So we thank you so much. And this is going to go to all our industry colleagues, and all of them, I'm going to be saying thank you from their side. Appreciate a lot, sir.
Thank you. Thank you.
Thank you. Don't miss any video from Insights with Nidhi. Subscribe to our channel and click the bell icon at the bottom of the video.